Oh, okay.
All right, Jacob Mound apparently was not brought over for behavioral reasons.
Defense will waive, Your Honor.
All right, the court finds probable cause, sets bond of $250. Michael Smith. Mr. Smith, in your case, the court finds probable cause for count 1, trespass on property after a warning, and count 2, resisting an officer without violence.
And Your Honor, the offer from the state was an adjudication of guilt, credit, time served, no return to 400 East Central Boulevard, and court costs. Mr. Smith would like to accept and enter a plea of no contest.
Okay. How much time served does Mr. Smith have?
3 days.
Mr. Smith, is this your signature here at the bottom of this plea form?
One.
Yes, ma'am.
Did you read the plea form in its entirety, sir?
Yes, ma'am.
Do you understand that by entering a plea of no contest, you're giving up the rights on this form?
Yes, ma'am.
Are you under the influence of any alcohol or drugs or medication?
No, ma'am.
Do you understand a conviction on your case will subject you to deportation if you're not a U.S. citizen?
Yes, ma'am.
There is a sufficient factual basis to accept your plea, and you are alert and intelligent. I'll adjudicate you guilty. Order 3 days in jail with credit for 3 days' time served. Order you not to return to 400 East Central Boulevard, Orlando, Florida, and order you to pay mandatory court costs. All court costs must be paid within 365 days of your release, and I am ordering your release as to this charge. Do you have any questions? You have the right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of today's date. Thank you, sir.
And, Your Honor, since he pled to the new law, I would ask that you take no action on the out on bond.
Granted, no action on the outer bond. Lincoln Felix.
Your Honor, he's medical.
Mr. Felix was charged by information, and I did find probable cause for all counts. Would you like to waive?
Yes, Your Honor.
All right, count 1, false imprisonment, bond stays at 500. Count 2, robbery by sudden snatching, bond stays at 100. Count 3, battery with the prior battery, bond stays at 2,500. Count 4, petty theft, bond stays at 100. The court's ordering no contact, no return. The court's ordering possess no weapons and no firearms, and surrender all weapons and firearms to law enforcement within 24 hours of release, and to maintain a separate residence. Avinash Hassan.
And Your Honor, he qualifies for pretrial.
All right. The court finds probable cause as follows. Count 1, battery or domestic violence by strangulation. Count 2, battery, domestic violence by strangulation. Count 3, false imprisonment. And count 4, battery, domestic violence. The court will order that you be released in the pretrial release program, and order that you have no contact with the victim and victims, no contact, no return, with the exception of a one-time visit with law enforcement to recover personal effects, that you possess no weapons and no firearms, and surrender any weapons and firearms to law enforcement within 24 hours of release.
Your Honor, is there separate residences as well? 'Cause I believe the location at this one was a hotel, so the no return would.
Yes, ma'am, I did order to maintain separate residences as well as no return, both. Hector Nieves.
Good morning, Your Honor. Jose Rivas here on behalf of Mr. Nieves, Judge.
Good morning, Mr. Nieves. The court finds probable cause for the charge of count 1, burglary of a dwelling with an assault or a battery. Bond will stay set at no bond. Count 2, violation of domestic injunction, and bond will stay at 500. And count 3, criminal mischief, bond will stay at $100. You were charged by information, and the court does find probable cause for each count.
Judge, if I may, the alleged victim is here. I've spoken to her, and I believe she doesn't have an issue with him having a bond.
Is she not in the,
I believe she needs a Spanish interpreter. Her name is Arecelis Gil.
who?
Last name is Gil? You told me she was here.
Can you spell it?
No.
G-E-O?
G-I-L.
G-I-L, Jill, is Miss Jill in the audience? Doesn't appear to be here.
Okay.
Is she here? No?
Evidently not. They,
Okay.
sorry, Your Honor, she's not here. She just, apparently she's not here.
Okay, it appears that she's not here.
Judge, I would like to do, I understand this is a PBL judge, but I would like to make an argument for a bond judge. My client's been in the community for over 33 years. He owns a pizzeria shop with over 20 employees. And more importantly, he has full custody of 2 children, 12 and 16, who he resides with, Judge. I mean, I spoke with the alleged victim this morning. I was trying to get a Zoom link. I don't mind postponing it, or actually, I don't know if the court will consider speaking to the victim via Zoom, so we can get her position on the bond. She informed me, and I would tell the officer of the court that she had no objection to a bond, him being released, or even on a GPS.
I don't know if I can speak to her via Zoom. Do the victims come in via Zoom, or do they have to come in person?
Come in person.
No, the victim needs to come in person.
Okay, I know she's a manager at a store, and she had to open her store, Judge.
She what?
She's a manager at a store, and she had to open her store. So my office was trying to contact her JA, get her a Zoom link, perhaps that could work. But nonetheless, Judge, I would ask the court,
The Zoom is not going to work. That's not going to work. But if she was here in person, she could testify. What says the state with regard to the request to set a bond?
Your Honor, the state would ask that it remain at no bond, given that it is a PBL, and we have not heard from the victim. And it has been filed, and probable cause has been found, so state would request that it stay at no bond, pending an Arthur hearing, which Mr. Rivas can set, where the victim would likely be present and a bond be set at that time.
All right, at this time, the court will decline to set a bond.
Thank
That's to count one. The court is ordering no contact, no return, possess no weapons and no firearms, surrender all weapons and firearms to law enforcement within 24 hours of release.
okay, thank you, Judge. Excuse me.
Thank you. Julian Sanchez Bedoya. In your case, the court finds probable cause as to count one, battery, domestic violence, bond is set at $500. Aggravated assault with a weapon, bond is set at $3,500. And battery, domestic violence, bond is set at $500. You're ordered to have no contact with the victim, no return, maintain a separate residence. You will be allowed a one-time visit with law enforcement to recover personal belongings.
Oh,
Oh, no, oh, can I unlock it? I don't know, I'll happily unlock it if you tell me how.
bad TVs.
Do I have to do that every time? I've never had to do that before. How do we let them know the panic button was pushed in error? Somebody's in there now. So- Do I have to do it every single time?
No, so when the victim left the last time, they slammed it.
Okay, okay, got it. All right, ma'am, raise your right hand to be sworn in. Do you swear that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, ma'am, I need you to speak just like you just spoke, loudly and clearly into that microphone. Either of the attorneys may have questions for you.
Okay.
Go ahead.
Has she been sworn?
Yes, I swore in.
Good morning, ma'am. Can you please state your last name?
Rodriguez,
And what is your relationship to Mr. Sanchez Bedoya?
he's my boyfriend.
Are you afraid of him?
I'm sorry?
Are you afraid of him?
Afraid? No.
Has anything like this ever happened before?
No.
If anything like this or anything more severe ever occurred in the future, would you feel comfortable calling 911?
Yes.
And do you want to have contact with him while this case is pending?
Yes.
Is there anything else you'd like to tell the court?
Anything else? What?
Is there anything else you'd like to say?
I just wanted to say that we were trying to get back together, and not everything that I wrote there is true.
All right, ma'am, thank you. You don't need to elaborate on that. At this time, does the state have any objection to the court ordering no contact, no hostile contact rather than no contact?
No, Your Honor, with all the other conditions and bonds.
All right, the court will order as a condition of release, no contact, no hostile contact with the victim, possess no weapons or firearms, surrender weapons and firearms, including knives, to law enforcement within 24 hours of release, no return, I will allow no hostile contact. You had a question, and I'll allow you to ask any question through your counsel.
Thank you.
All right, thank you. Ma'am, you're excused.
Thank you.
There you go. Did I hear you two or just one? Okay, Jonathan Santana. Sir, in your case, the court finds probable cause for the charge of cruelty toward a child and sets a bond of $3,000. You're ordered to have no contact with the child, not return to the location where this incident occurred, with the exception of a one-time visit in the presence of law enforcement to recover your personal belongings and effects. You are further ordered to surrender any weapons or firearms to law enforcement within 24 hours of release and comply with any DCF ordered plan. Thank you. Anthony Steele. Ms. Keys, is that you? Yes or no?
I didn't say anything.
What's your name?
I'm Jason Steele.
No, not you. You.
Yes,
I said, Ms. Keys, is that you?
yes, that's me. I thought you said I said something.
No, I just want to be sure it's you, because with the mask, it covers over half of your face, and I wanted to be sure it was you before I started asking you questions. Mr. Steele, in your case, the court finds probable cause for count 1, child abuse, and a bond is set at $3,500, and count 2, false imprisonment. Bond is set to $500. The court is ordering you to have no contact with the victims in this case, no contact with the family of the victims, no return with the exception of one time to recover any personal belongings that you may need, possess no weapons and no firearms, and surrender all weapons and firearms to law enforcement within 24 hours of release.
Your Honor, I also believe DCF was contacted.
Oh, yes, also in this case, the court is ordering you to comply with any DCF ordered plan. Thank you. Xavier Stinson. Mr. Stinson, the court finds probable cause for the charge of aggravated battery on a pregnant person. And there's a witness, ma'am. I'm gonna swear you in. As a matter of fact, I'm gonna swear everybody in. Everybody, please stand and raise your right hand to be sworn in, everybody. Do you all swear or affirm that you will tell the truth, the whole truth, and nothing but the truth when you come to testify?
Yes.
So help you God?
Yes.
Okay, thank you, ma'am. Thank you, everybody. Please sit down. All right. One of the attorneys or both of them may have questions. What you need to do is just answer any questions they ask directly into the microphones to be sure that we all hear you. Go ahead, counsel.
Good morning, ma'am. Can you please state your name for the record?
My name,
Yes.
Andrazia Chisholm.
And what is your relationship to Mr. Stinson?
My boyfriend.
Are you afraid of him?
No,
Has anything like this ever happened before?
no,
If anything like this or anything more severe ever occurred in the future, would you feel comfortable calling 911?
yes,
Do you believe drugs or alcohol were involved in this incident?
no,
And do you want to have contact with him while this case is pending?
yes,
That's all I have, Your Honor.
All right. The court finds probable cause and sets a bond of $2,500, orders no hostile contact with the victim. Further, possess no weapons and no firearms, and surrender any weapons or firearms to law enforcement within 24 hours of release. As to your second case, possession of a controlled substance, The court finds probable cause and bond stays at $1,000. You're ordered to consume or possess no controlled substances or no narcotics without a prescription as a condition of your release. The court is ordering random urinalysis or random drug testing to be conducted by the pretrial release program. Thank you, sir.
Your Honor,
Yes, ma'am.
can the drug test be conducted 30 days?
Yes, ma'am. The first random test should be conducted no sooner than 30 days from now. I think that's the right way to say it. Coy Stout. Mr. Stout, in your case, the court finds probable cause as follows. Burglary of a dwelling with an assault or battery. Bond will stay at no bond. Battery or domestic battery by strangulation, bond is set to $500. False imprisonment, bond is set to $150. As conditions of release, the court is ordering no contact, no return, with the exception of one time with law enforcement to recover personal belongings and effects, possess no weapons and no firearms, and surrender all weapons or firearms to law enforcement within 24 hours of release. Thank you. Ramad Terry. Mr. Terry, in your case, the court finds probable cause for aggravated battery on a pregnant person, and bond is set to $2,500. You're ordered to have no contact with the victim, maintain a separate residence from the victim, no return to the place where this happened, possess no weapons and no firearms, and surrender all weapons or firearms to law enforcement within 24 hours of release. Thank you, sir. Aisha Atkinson.
Your Honor, she qualifies for pretrial.
Thank you, Ms. Keys. Ms. Atkinson, the court finds probable cause for battery, domestic violence, count 1, and battery, count 2, and I will order you to be released in a pretrial.
I apologize, she doesn't qualify.
She does not qualify?
She hasn't been interviewed yet.
Okay, then I'll do it in an alternative. I will order you, as in the alternative, to post a bond of $500 as to count 1 and $500 as to count 2, or participate in the pretrial release program if you qualify. Conditions of bond or pretrial release are to maintain a separate residence, possess no weapons and no firearms, surrender any weapons or firearms to law enforcement within 24 hours of release, and have no contact with your brother or the victim or the girlfriend.
Your Honor, DCF was also contacted on this case.
And ma'am, also comply with any DCF ordered plan in this case. She doesn't qualify for the public defender due to her income.
Okay.
You'll have to hire your own legal counsel. Thank you, ma'am. Junior Bastian. In your case, the court does find probable cause for battery, domestic violence, and I set a bond of $500. Further, I'm ordering you to have no contact with the victim, no return, with the exception of one time in the presence of law enforcement to recover personal belongings, maintain a separate residence, possess no weapons and possess no firearms, and surrender any weapons or firearms to law enforcement within 24 hours of your release. Thank you, sir. Shalom Calloway.
Mental health, Your Honor.
And she qualifies for pretrial.
Defense will waive, Your Honor.
Court finds probable cause and orders pretrial release. No contact with the victim, no return with the exception of one time for personal belongings or effects in the presence of law enforcement. Possess no weapons, no firearms, and surrender all weapons or firearms to law enforcement within 24 hours of release. Public defender is appointed. Jason Caraballo.
He's mental health, Your Honor.
Public defender will be appointed in this case. Would you like to waive?
Yes, Your Honor.
All right, the court does find probable cause for the charge at battery and sets a bond of $500. No contact with the victim, no return, with the exception of one time to recover personal belongings or effects. Possess no weapons, no firearms, and surrender all weapons or firearms to law enforcement. No action on the out on bond. Peter Chigani.
And he qualifies, Your Honor.
Mr.
Good morning, Your Honor.
Good morning,
May it please the court, Hal Urick for Mr. Chigani.
Mr.
Notwithstanding the fact that he qualifies, we're going to be asking, and I've already spoken with the state, asking for you to set a $500 bond in place of the pretrial release.
Okay,
There's an additional issue. In this case, the event took place in Mr. Chigani's home. His sister, who is the alleged complainant in this case, lives 4 houses down, 184 feet. There's a typical requirement of a 500-foot separation. We would ask that to be amended to 100 feet so they can reside in their respective residences with a no-contact provision.
okay. State, do you have any objection to those requests?
No, Your Honor. With the understanding that Mr. Chigini, if he sees the victim, he must turn the other way, make sure that there's no contact.
Okay.
Let's say there's no objection.
Mr. Shigini, there is probable cause for the charge of battery. The court will order you to post a bond of $500, order you to have no contact with the victim, to maintain a distance of at least 100 feet from the victim at all times. And no contact means no direct or indirect contact with the victim. Further, the court is ordering you to surrender any weapons or firearms to law enforcement within 24 hours of release, as well as that you are ordered to possess no firearms or weapons while on bond. Thank you, sir.
Thank you, Your Honor.
Thank you.
Court and personnel have a great day.
Do the same. See, they still fogging up, no matter what. I need a little windshield wiper. Darvis Ortiz,
Good morning, Your Honor.
good morning.
Good to see you at
Yes.
the jail.
Yes, we are here. For the record, counsel, you're Mr. Zlatkin?
Yeah, Attorney Robert Zlakin for the record on behalf of Darvis Ortiz.
All right, a public defender does not, he does not qualify. I'm not appointing the public defender. And Mr. Zlatkin, I am finding probable cause for the charge of contempt of court for violation of an injunction against stalking and setting a bond of $500, conditions of no contact, no return, no contact, direct or indirect.
Your Honor, there is a witness here.
There's what?
As a witness, yeah.
Oh, I'm sorry, I didn't even see her. Ma'am, you've already been sworn in, so we just need your name.
My name is Gabriela Collar.
Okay, and the attorneys may have questions from you, so make sure you answer the questions as loudly as you can into your microphone.
Yes, ma'am.
Good morning, Ms. Collar. Can you please state your relationship to Mr. Ortiz?
He's the father of my children.
Are you afraid of him?
Yes, ma'am.
Has anything like this ever happened before?
Yes, ma'am.
Approximately how long ago would you say the last time was?
Maybe 2 years ago.
Has there been a prior violation of an injunction?
Yes, ma'am.
Approximately how long ago was that?
Oh, my goodness. I've had an injunction a year ago. And now this one. So I've had 2 injunctions, but the first one got denied because he was in jail, and then he made bail.
And do you want to have contact with him while this case is pending?
No, ma'am.
That's all I have, Your Honor.
Your Honor, if I can say something?
Yes, ma'am.
I had to drive down last night to Miami-Dade and file new charges against Darvis Ortiz. He has violated the injunction and the no contact order that the judge in Miami-Dade placed. He has violated it 6 times. In total, I am in contact with the state attorney in Miami-Dade as well. So I just wanted to let you know that information.
Thank you for that information, and I'm sure the state will follow up on that information if necessary. I'm ordering you to have no contact with the victim whatsoever. I'm ordering, instead of $500 bond, I'm increasing the bond to $1,000. Further, I'm ordering you to surrender any weapons or firearms to law enforcement within 24 hours of release, as well as possess no firearms or weapons as a condition of release. You're ordered to maintain at least 500 feet distance from the victim and have no contact with either the victim or her family. If there is a DCF plan, you are ordered to comply with it in this case. Thank you. Thank you, counsel.
Thank you so much, Your Honor. And that's all I have before the court.
Thank you.
Pleasure as always.
William Real? Sir, in your case, the court does find probable cause for the charge of battery, domestic violence, and sets a bond of $500. No contact with the victim, no return with the exception of a one-time visit to recover any personal belongings or effects, maintain a separate residence. Further, you must possess no weapons and no firearms and surrender any weapons or firearms to law enforcement within 24 hours of release. Thank you, sir. Oksana Anita Smithe,
As an alternate,
Qualifies for pretrial, Your Honor.
all right.
I don't know. Your Honor, before we move on, he's, could you,
Yes, ma'am.
Can you, pretrial, could you please advise, I see that he didn't qualify only because an alternate address was provided, but he stated he provided one.
No, he has another warrant in Virginia.
Okay, that's why he doesn't.
Yes.
Thank you. So you don't.
Thank you, Ms. Keys. Ms. Oksana Smithe? Ma'am, in your case, the court finds probable cause for battery, domestic violence. You do qualify for the pretrial release program. I am ordering you to be released via pretrial release, ordering the following conditions. You must comply with all terms of pretrial release and have no contact with the victim. Not return with the exception of a one-time visit with law enforcement to recover personal belongings. Possess no weapons and no firearms and surrender any weapons or firearms to law enforcement within 24 hours of release. You're ordered to comply with any DCF ordered plan in this case. Levitt Stevens,
He qualifies for pretrial as well, Your Honor,
all right.
or she.
All right, sir, you've already been sworn in, and one or both of the attorneys may have questions of you. So tell me what your name is first.
Cedric Stevens.
All right, Mr. Stevens. The attorneys may inquire.
Good morning, Mr. Stevens. Can you please state your relationship to Labette Stevens?
My wife. I'm her husband.
Are you afraid of her?
No, ma'am.
Has anything like this ever happened before?
No, ma'am.
If anything like this or anything more severe ever occurred in the future, would you feel comfortable calling 911?
Yes.
And do you want to have contact with her while this
Yes,
case
I
is
will.
pending? All right, thank you. Citizen for the questions, Your Honor.
All right, in your case, Ms. Levitt Stevens, the court finds probable cause, and I'm ordering you to be released in the pretrial release program. She does not qualify for the public defender, so in this case, I won't be appointing the public defender. But her income doesn't seem to be that great. Ma'am, you can always reapply for the public defender and have the judge reassess whether you qualify at your next court hearing. You understand?
I don't understand.
Okay, so you don't qualify for the public defender because you make too much money. You understand that? All right, so sometimes people, their income fluctuates. And so if by the next court date, if your income has changed in any way, you can always ask the judge to let you reapply, and you can see if you qualify at that time. In the meantime, you can try to hire your own private lawyer. You understand? Okay. I'm ordering you to have no hostile contact with the victim, possess no weapons and no firearms, and surrender any weapons or firearms to law enforcement within 24 hours of your release. Further, ma'am, you must comply with all the terms of the pretrial release program. Thank you, ma'am. You may exit. Thank you, sir. Othel Watson.
And he qualifies, Your Honor.
Thank you. Mr. Watson, in your case, the court does find probable cause for battery, domestic violence. You do qualify for pretrial release, and I'm going to order you to be released in a pretrial release program. We have a witness. You've already been sworn in, so I just need you to tell us what your name is for the record.
Titus Hepburn.
Okay, thank you, Mr. Hepburn. You're going to have questions that are going to be asked by one or both of the attorneys. Please answer all questions into the microphone.
Good morning, Mr. Hepburn. Can you please state your relationship to Mr. Watson?
Boyfriend.
Are you afraid of him?
No.
Has anything like this ever happened before?
No.
If anything like this or anything more severe ever occurred in the future, would you feel comfortable calling 911?
Yes.
Do you want to have contact with him while this case is pending?
Yes.
All right, thank you. State is no further questions, Your Honor.
All right, sir. As a condition of pretrial release, I am ordering you to comply with all the terms of pretrial release and also to have no hostile contact with the victim and to possess no weapons and no firearms and surrender all weapons or firearms to law enforcement within 24 hours of release. Thank you. Thank you, sir. Robert Bruce. Oh, I'm sorry. It locked, okay. Why don't we do the thing that the old-fashioned thing, stick some wadded paper towels in there, keep it from closing. We too fancy for wadded paper towels?
Actually a good idea.
We've gotten too fancy. All right, Robert Scott Bruce, you were picked up on an out-of-county warrant from Seminole County. Bond shall stay set at $8,000 on count 1 for dealing in stolen property and $3,000 on count 2 for grand theft motor vehicle. Public defender is appointed. Michael Scott Bruno, you were picked up on an out-of-county warrant from Polk. Bond will stay set at no bond, and the public defender is appointed in your case. Kushan Rayner, you were picked up on an out-of-county warrant, 3 counts, battery on a Leo, fleeing or attempting to elude, resisting an officer with violence. Bond will stay set at $1,000 on each count. Landon Robinson, you were picked up on an out-of-county warrant from Marion, and bond will stay at $500 for the charge of leaving the scene of a crash. Thank you. Frank Santana, sir, you were picked up on an out-of-county warrant from Pasco, and bond will stay set at $25,013 for felony drug possession of a controlled substance without a prescription. Cedric Sevier, sorry.
He bonded, Your Honor.
All right, Mr. Sevier previously bonded per jail staff. Marquavius White. Mr. White, you were picked up on an out-of-county warrant from Pinellas, and bond will stay set at $2,013 for driving on a suspended license. Thank you, sir. I did appoint the public defender, so we'll allow the public defender to inform me of whether they want you to talk.
No.
Okay. Preston Mayer? In your case, sir, it's a violation of probation, condition 5, which is a new law violation for battery on a person 65 years of age or older, and bond will stay set at no bond in that case.
Your Honor, may I speak?
I've appointed the public defender. The public defender will inform me of whether they want you to speak or not.
violation occur?
7 months ago. I was on probation, but
So there's
she knows me.
On or about April 12th, 2022.
I didn't do the violation. They accused me of doing something at my workplace. Yeah. But that's not what she's stating. What she's stating. I'm just trying to be technical, so maybe I can get up. Maybe I can get.
Your Honor, he would like to know if you are willing to set a bond. He's stating the underlying charge was dropped.
The judge on the case has ordered no bond,
She can't.
and Judge Elaine Barber, that is who you will need to make your request for any modification of the bond. Mr. Atkins, the court finds probable cause on your case for trespass on property after a warning and sets a bond of $250.
Your Honor,
Yes, ma'am?
the state was not making an offer on this case. I was gonna ask for a bench off.
Mm-hmm.
Just give me a second. You guys distracted me. I'm sorry. So, Your Honor, I am asking for a bench offer of an adjudication of guilt, credit time served. Based on his history, I know the state's concern was the last conviction of exposure of sexual organs. He's transient. He was using the restroom outside.
Okay.
So I just asked for an offer of an adjudication credit time served to resolve the case.
Can you tell me more about that last conviction?
Well, Your Honor, the state didn't give me an offer because he originally, law enforcement called the scene due to a juvenile making a phone call.
Uh-huh.
That he was making her uncomfortable. State wanted more information on that
Okay.
before conveying an offer, given that his last conviction was that exposure of sexual organs, and given that he is out on bond for another case as well.
Wow. Okay. The court, considering the state's concern and considering the facts that are indicated in the probable cause affidavit, the court will not accept a plea at this time. However, I am ordering a bond of $250, which is a bit of a reduction, and ordering no return, no contact with the caller, the victim, no return to the location where that incident occurred, and no contact with any minor children under the age of 18, unless they are his own biological children. The court will not take any action on the case he's currently out on bond on.
No, they won't give you credit time.
Thank you. Thank you, sir. Doreen Curry. Doreen Curry, in your case, the court finds probable cause for the offense of trespass on property after a warning and will set a bond. Miss, did you have something to add?
Yes, Your Honor. The offer from the state is an adjudication of guilt, credit time served, no return to
I
South.
do not, hold on, I can't do that. I went where I was not trespassing.
Okay.
The
Well,
court will set a bond of $250, order no return, no contact with the,
I believe it was an overpass, Your Honor.
oh, no return.
408 overpass.
These classes don't want to stay on. I'm gonna have to get some things to put on the back. Anthony Albert. Mr. Albert.
Your Honor, are we gonna skip the arraignment?
Oh, no, we'll do the arraignments. Oh, we're still holding? Okay, yeah. Let's go ahead and do the arraignments. I think that's who's next in line, correct? Okay. Shanna Marie Santiago. Restricted? Public defender was previously appointed on this case. Ms. Public Defender, waiver of arraignment?
Yes, Your Honor, we'll waive and enter denial.
All right, we'll set it for a BOP's status hearing.
BOP status date will be October 17th at 1:30 in courtroom 6C.
Thank you. Jerry Warren Kemp, Jerry Kemp Warren. Sir, you're here for an arraignment for violation of probation on your DUI probation. Condition 7, failure to keep an appointment on July 18th and on August 15th, 2022. And special condition, failure to enroll in your DUI counterattack class and complete it as ordered by the court. Public defender was appointed.
I will enter denial.
All right, set for a BOP status.
BOP status date will be December 12th at 8:30, courtroom 12C.
Sir,
December 12th?
yes, ma'am.
Okay.
Sir, legal counsel will let me know if they wish you to inform me of anything.
Is that for both of his cases?
Oh, he also has a new law, sorry, Mr. Kemp, Warren, Mr. Warren.
Thank you.
You do have another case for which I need to arraign you, and it is the, new law of operating a motor vehicle without a valid driver's license. Ms. Public Defender, I believe your office has previously been appointed on that case as well.
We'll enter a plea of not guilty, Your Honor.
All right, and that will be set for a pretrial.
What case number is that, Judge? I'm sorry.
Madam Clerk, I can give it to you. What do you have?
Warren Lindsay, okay, I'm sorry. That's 2022 CT 3273.
Yes. Thank you, ma'am.
This case will be here in Division 84. Pretrial conference date will be October 20th at 8:45. Trial period begins November 7th through November 9th.
Thank you. O'Shane Mitchell,
She's in restricted housing, Your Honor.
Public defender was appointed. Would you waive her appearance for this?
Yes, Your Honor, enter denial.
All right, a denial is entered. We'll set this case for a VOP status.
Status date will be October 28th at 9 a.m. in courtroom 10B.
Thank you. Maxwell Zoran Mackay Wilcox.
Yes, Your Honor. There was an offer to resolve Mr. Wilcox resisting an officer without violence. The state's offering an adjudication of guilt, credit time served, and Mr. Wilcox would like to accept and enter a plea of no contest.
All right, so a lawyer from the public defender's office filed a waiver of arraignment, a written plea of not guilty. So does he want to resolve it or talk to that other lawyer?
Do you want to wait and speak to your lawyer? Or do you want to resolve it? I don't know. I didn't see any notes. Have just a moment, Your Honor.
I think he's revoked on another case. I don't think he's going anywhere.
He's not.
What are you checking out?
When I looked, I didn't remember.
Well, I'm telling you, a lawyer from the public defender filed a written plea of not guilty. Take my word for it.
Oh, no, Your Honor, I was looking to see if she put a particular note, because when I looked at the case, he had multiple charges with the resisting, but the state only moved forward on the resisting charge. So I didn't know if I missed something.
Okay.
Because of that. That's why I was like, I don't want to, if she entered the waiver.
Well, she did. So if that's what you're looking at, that's a bit of a unnecessary action.
They waived your arraignment. I just don't know why, because it didn't have any notes. That's what I was looking at to see any notes, Your Honor. I didn't see any notes of why he shouldn't take it.
No. Yes.
Okay.
There's no need to waive someone's arraignment if they're in jail. And they know you work out here and they know you can resolve the case. So will you please confirm that he's not on probation? There's nothing that's going to violate him. There's no reason why the lawyer felt a need to waive his arraignment.
Yes, Your Honor. I didn't see anything. I'm double checking again.
Okay,
I don't see anything as to why he could not resolve this case.
all right. Same for you, Ms. Fleming?
Yeah, sure. I don't have any other knowledge about anything.
Okay. Okay, the Creole interpreter's gonna have to wait until I finish with the plea on Mr. Wilcox. All right, Mr. Wilcox. Is this your signature here at the bottom of this plea form, sir? And did you? That noise is a bit of a distraction. All right, sir, did you read this plea form before you signed it? Are you under the influence of any alcohol or drugs or medication? Do you understand that a conviction on your case will subject you to being deported if you're not a U.S. citizen? All right, there is a sufficient factual basis in your case, and you're alert, you are intelligent. I'll adjudicate you guilty. How much time, sir? How much time served on Maxwell Wilcox?
38 days.
Sentence you to 38 days in the jail with credit for 38 days time served. Further, sir, I'm ordering you to pay all mandatory court costs associated with this charge within 365 days of your release from incarceration, and I am ordering your release as to this charge. Thank you, sir. Joshua, well, that happens. Sean Young. It happens a lot.
Oh, I'm sorry, Your Honor, he's in restricted housing.
Public defender was previously appointed in this case.
Defense will waive and enter a denial, Your Honor.
All right, a denial is entered. Let's set this for BOP status.
Status date will be November 30th at 9 a.m. Courtroom 9B.
Thank you. Anthony Ray Albert. Mr. Albert, sir, in your case, the court finds probable cause for petty theft and sets a bond of $250 and orders you to not return and have no contact with the victim. Thank you, sir. Maxim Alexandrovich Dunessos. Sir, in your case, the court finds probable cause for trespass on a school ground or facility and carrying a simulated firearm. Bond stays at $250 on count 1 and $100 on count 2. You're ordered to have, to not return to the location where this incident occurred, to possess no weapons and no firearms as a condition of release, and surrender any weapons or firearms to law enforcement within 24 hours of release. You're also ordered to have no contact with minor children under the age of 18 unless they are your biological children or, yes, biological children. Ronald Pratt. Mr. Pratt, in your case, the court finds probable cause for trespass on property after a warning.
Your Honor, there was an offer to resolve the case with an adjudication of guilt, credit time served, no return to 307 Park Lake Circle, and Mr. Pratt would like to accept and enter plea of no contest.
Okay, is Park Lake Circle in Orlando, Florida, or some other city?
Orlando, Your Honor.
Orlando, Florida.
Okay. How much time served does Mr. Pratt have?
2 days.
2?
Yes.
Mr. Pratt, is this your signature here at the bottom of this plea form? Mr. Pratt, sir, is this your signature here at the bottom of this plea form? Can you hear me, Mr. Pratt?
I hear you, but I don't understand what you're saying.
Okay, well, then I guess you can't hear me that well.
I hear you perfect, ma'am. I just don't understand what you're saying.
Oh, I'm sorry. If you hear me but you can't understand me, then I don't know what to do.
I agree, ma'am.
No. Did you have trouble with his comprehension when you spoke with him, Ms.?
No, ma'am.
No, Your Honor, I didn't have any. He understood. I did also give him the back of the form to review, and he didn't have any issues. He may not know what the form is called. That's probably what it is.
Yes, ma'am.
Oh, sir, did you sign a document that the lawyer standing next to you gave you?
Yes, ma'am.
Did you read it before you signed it?
Yes, ma'am.
No, it is a plea form. Do you understand you're entering a plea of no contest today?
Yes, ma'am.
All right. Are you under the influence of any alcohol or drugs or medication?
No, ma'am.
Do you understand that a conviction on this case will subject you to deportation if you're not a U.S. citizen?
Yes, ma'am.
All right. There is a sufficient factual basis in this case, and you are alert, you're intelligent. I'm going to adjudicate you guilty. I don't know if I got the time served. Can you repeat it?
2 days.
Sentence you to 2 days in jail with credit for the 2 days you served. Order you to not return to 307 Park Lake Circle in Orlando, Florida. And further, I am ordering you to pay all mandatory court costs associated with this charge, which must be paid within 365 days of your release from incarceration. And I am ordering your release from incarceration from this case. Do you have any questions?
No, ma'am, I don't.
You have the right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of today's date.
Yes, ma'am.
Thank you, sir. Lamont Reed,
Your Honor, his behavior,
public defender is appointed.
Your Honor, there was an offer to resolve. Can we waive till, can we roll till tomorrow?
Yes, this case will be reset for Thursday. Lisa Reimer. Ma'am, in your case, the court finds probable cause for trespass on property after a warning.
And, Your Honor, the offer from the state is an adjudication, credit time served, no return to 2803 West Arlington Street in Orlando, Florida, and court costs. And Ms. Reimer would like to accept and enter a plea of no contest.
Thank you. And what is Ms. Reimer's time served?
2 days.
Ms. Reimer, ma'am, is this your signature here at the bottom of this plea form? Did you read this plea form before you signed it? Did you read this document? Ma'am, did you read it?
Yes, I did.
Okay. Are you under the influence of any alcohol or drugs or medication? Do you understand that a conviction on this case will subject you to deportation if you're not a U.S. citizen? All right, ma'am, there is a sufficient factual basis in your case, and you are alert and intelligent. I will adjudicate you guilty, order you to serve 2 days in jail with credit for 2 days' time served, and order you to not return to 2803 West Arlington Street, Orlando, Florida. Further, you must pay all mandatory court costs associated with this charge within 365 days of your release, and I am ordering your release as to this charge. You have a right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of today's date. Any questions? Thank you, ma'am. Lorica and Tasia Young. Ms. Young, in your case, the court finds probable cause for petty theft. Bond stays at, well, the court will set a bond of $250, and battery bond is set at $500.
answer, Judge.
No, ma'am, it's to count one. I switched it. Count one is $250. Count two is raised to $500. Ma'am, where did she go? Yes, I do.
Young.
Young.
They move fast. Ms. Young, ma'am, the conditions of your release are that you not return to the location where this incident occurred and that you have no contact with the victim whatsoever, that you possess no weapons and no firearms, and surrender any weapons or firearms to law enforcement within 24 hours of release. Thank you, ma'am.
That's it, Michelle, you good.
That's it.
Is that it, Judge?
Yes, ma'am, that's it.
All right, thanks.
Thank you, too. Damian Kareem Jones. Mr. Jones, in your case, the court finds probable cause for battery and bond will stay set at $1,000. You are ordered to have no contact with the victim, no return, maintain a separate residence. Further, you're ordered to possess no weapons and no firearms and surrender any weapons or firearms to law enforcement within 24 hours of release. The court will take no action on the case that he was out on bond on. Thank you, sir. Tabitha Martinson. Tabitha, Ms. Martinson, you were picked up for failure to appear.
And, Your Honor, on this failure to appear, the state is making an offer to resolve the case within adjudication of guilt, credit time served, no return to 13707 West Colonial Drive in Orlando, Florida. There is restitution in the amount of $11.57 in court costs.
Who is the restitution payable to?
It's the Speedway, Your Honor, or a registered representative.
And I will need a restitution order, state.
I'm preparing it right now, Your Honor.
Okay,
And Ms. Martinson would like to accept and enter a plea of no contest, Your Honor.
okay. Ms. Martinson, is this your signature here at the bottom of this plea form? Did you read this plea form in its entirety before you signed it?
I understand it.
Did you read it? Ms. Martinson, I'm gonna need you to read the plea form.
Yeah, it's the same one.
So, did she read it?
Yes, Your Honor, it's this form. I pulled the back off. She didn't
Okay.
understand. But she-
All right, Ms. Martinson, you did read the plea form?
I understood what she was saying. I read over it, no, but I knew what it was, so.
Okay, we're gonna just give her an opportunity to read the plea form. All right, and in the meantime, we can take the case involving the Creole interpreter, which is Mr. Diano Renard.
Your Honor, he qualifies for pretrial.
All right. This is Judge Allen. Is the Creole interpreter on the line?
Yes, Your Honor, I am. My name is Cecile.
Cecile?
Yes, ma'am.
All right, Ms. Cecile, we're going to, well, first, have you been sworn in? We're going to have the
I
clerk,
haven't been sworn in.
we're going to have the clerk to swear you in, Ms. Cecile.
Yes, Your Honor, thank you.
Do you solemnly swear to translate from Creole to English and English to Creole, so help you?
I apologize. Could you please a little bit louder because I cannot hear you.
Do you solemnly swear or affirm to translate from Creole to English and English to Creole, so help you?
I do.
Thank you, Ms. Cecilia.
You're very welcome, Your Honor.
The defendant is at the podium, and you may go ahead on and begin translating now when I start talking. Mr. Renard, good afternoon.
Bonsoir, Monsieur Renard.
In your case, you're charged with use of a counterfeit validation sticker, and count 2, a counterfeit license plate.
Yo te chargé ou parce que ou te servi avec plaque machine pour te servir avec pour valider que bagay ou te fait avec ou.
The court is ordering the bond on count 1 to stay at $2,500
Your
and setting the bond on count 2 at $500.
Tribunal a décidé pour premier pénalité pour les $2,500 et puis deuxième pénalité à $500.
Your Honor, he does qualify for pretrial release. I would ask for pretrial release in this case.
Does he qualify for pretrial release, Ms. Keys?
Yes.
Ms. Interpreter, can you just inform the defendant as follows? Mr. Renard, you qualify for pretrial release.
Monsieur Renard, juge la faut connaître que vous qualifiez pour yo vo la caillou avant yo fait jugement.
So instead of ordering you to post a bond, I'm going to order you to participate in the pretrial release program.
Au lieu pour ta bay un bon, vous mettez l'argent, yo ta faut participer dans un programme qui est le pretrial release là. Ça veut dire pour yo pas mettre en prison avant yo faire jugement.
And you must comply with all of the terms of the pretrial release program.
C'est pour observer tout l'ordre que vous passez pour qui est en rapport avec pretrial release là.
Thank you, sir. You're excused now.
Your Honor, he has another case.
Merci, monsieur.
Oh, wait.
Excusez au
Madam Interpreter,
Yes, Your Honor.
he has a second case, so let me inform him of his second case. Tell him I need him to hold on for a moment.
Attendez un petit moment, monsieur Renard, parce que libre à l'informer au sujet de deuxième charge là.
As to your second case, the charge is abuse or misuse of a temporary tag.
Deuxième charge là, c'est parce que vous êtes servi avec une plaque machine temporaire ou bien vous êtes abusé.
The court will also order pretrial release as to that case as well.
Tribunal là pour ordonner pour le programme et pour yo laguer pour yo arrêter avant que yo fait jugement.
Thank you, sir.
Merci, monsieur.
You're excused.
On m'aide à aller connaître.
Ms. Interpreter, thank you for your assistance. We appreciate it.
You're very welcome, Your Honor. Thank you for using our services.
Our
Have a
pleasure.
wonderful day.
You do the same.
Thank you.
Thank you.
Thank
Ms.
you.
Martinson, have you now had a chance to read your plea form, ma'am?
Yes, ma'am, I understand. Where, can I pay that $11 at, like, the courthouse in Ocoee or the clerk of courts or something like that? Is that where I pay that at?
Yes, ma'am, that's exactly right. And so, ma'am, now that you've had a chance to read the plea form, just answer a few questions for me. Is this your signature at the bottom of the plea form?
Yes, ma'am.
Do you understand that by
Goodbye.
entering your plea of no contest, you're giving up the rights on the plea form?
Yes, ma'am.
Are you under the influence of any alcohol, drugs, or medicine this afternoon?
No, ma'am.
Do you understand a conviction on your case will subject you to deportation if you're not a U.S. citizen? There's a sufficient factual basis in your case, and you are alert and intelligent. I'll adjudicate you guilty. Time served.
37 days.
Order 37 days in the Orange County Jail with 37 days credit for time served. And I'm ordering you to not return to 13707 West Colonial Drive in Orlando or Ocoee?
It's Orlando, Your Honor.
Orlando, Florida. Further, I am ordering you to pay restitution of $11.57 to the Speedway. You'll have 365 days to pay all the court costs, and I'm gonna give you 180 days to pay the restitution. Do you have the restitution order ready?
Yes, Your Honor, may I approach?
Yes, ma'am.
No, Speedway was in Winter Garden.
It will have the right address on here. You'll still pay the restitution at the clerk of courts, and the clerk of courts will mail it to the Speedway, so you don't have to try to figure out which one it is, okay? But I am giving you 180 days on the restitution, and I am giving you 365 days on the court costs.
Okay.
Do you have any questions?
No, ma'am.
You have the right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of today's date. Thank you. Jonathan Larinaga,
Yes, ma'am.
in your case, the court finds probable cause for disorderly conduct. Is there an offer?
Yes, Your Honor, the offer is an adjudication, credit time served, and court costs. And Mr. Larinaga would like to accept and enter a plea of no contest.
Thank you. What's his time served?
2 days.
Mr. Larinaga, is this your signature here, sir, at the bottom of this plea form?
Yes, it is.
Did you read this document before you signed it?
Yes, I did.
Are you under the influence of any alcohol or drugs or medicine?
No, I am not.
Do you understand that by entering your plea of no contest, you're giving up all the rights on the plea form?
Yes, ma'am.
Do you understand a conviction on this case will subject you to deportation if you're not a United States citizen?
Yes, ma'am.
Sir, there's a sufficient factual basis in your case, and you are alert and intelligent. I'll adjudicate you guilty, order 2 days in jail with credit for 2 days' time served. Further, I'm ordering you to pay mandatory court costs, which must be paid within 365 days of your release, and I am ordering your release as to this charge. Any questions?
No, ma'am.
You have the right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of today's date. Thank you, sir.
Thank you.
Clarence Quentin Francis. In your case, the court finds probable cause for count 1, expired driver's license, bond stays at 500, and count 2, driving on a license that was suspended, bond stays at 500.
Your Honor,
Yes, ma'am?
the offer from the state to resolve both cases was an adjudication of guilt, credit time served. I was just double checking to see if his bond was posted.
I don't know.
I was asking him pre-trial, I don't know.
No,
But he-
bond hasn't been posted yet.
So he would like to accept and enter a plea of no contest, he said.
All right. How much time, sir?
2 days.
Mr. Quentin, sir, is this your signature here at the bottom of this plea form?
Yes.
Did you read the plea form before you signed it?
Yes, Your Honor.
And are you under the influence of any alcohol, drugs, and medicine today?
Oh, yeah.
You understand that by entering your no contest plea, you're giving up all the rights on the form? And you understand a conviction on this case will subject you to deportation if you're not a U.S. citizen?
Yes, Your Honor.
All right, there's a sufficient factual basis in your case. You're alert, you're intelligent. The court will adjudicate you guilty, order 2 days concurrent as to count 1 and count 2, order mandatory court costs, which must be paid within 365 days of your release, and I am ordering your release as to this case. Do you have any questions?
No, Your Honor.
You have the right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of today's date. Thank you.
Do we just ignore the writ since he's not seen an IA for that?
I'm sorry, ignore a writ?
his writs have been paid, but the 2 charges that's here hasn't been paid.
I know nothing of the writ. What writ are we talking about?
He has a writ, a bodily attachment as well. It came in as an out-of-county warrant.
Do I have that?
Usually we don't see writs here at IA, that's what I was asking.
Yes, he bonded on those. He just
What-
didn't
No,
bond on
so,
the
no, that's not
traffic
something.
charges.
So, Ms. Fleming, were you asking me?
No,
Oh, okay, all right. Mr. Davidan Milo?
Yes,
In your case, the court finds probable cause for no valid driver's license. Bond will stay set at $500. You have an out on bond DUI for which I'm revoking the bond and ordering no bond. 2022 CT 2420, Osceola County. No, actually, I'll order a $5,000 bond on that case. There are 2 other out on bond cases. I'm not going to take any action on the other 2 out on bond cases. Public defender is not appointed in that case. No, you guys can give me a note, but I looked at it. Douglas Archie. Mr. Archie, the court finds probable cause for possession of cannabis with intent to sell or deliver with a weapon. Bond will stay in your case at $7,500. You're ordered to possess no weapons or firearms as a condition of release. Surrender all weapons or firearms to law enforcement within 24 hours of release. Moses Blakes. In your case, the court finds probable cause for being a sex offender and failing to register or report as required, and sets a bond of, why did I not write a bond amount on? Oh, $2,000. As to your out on bond case, the court revokes that bond and orders a new bond of $5,000. You're ordered to report within 24 hours of release as required to register as a sex offender. Report within 24 hours. Jesse Butler. Mr. Butler, in your case, the court finds probable cause for possession of a controlled substance and orders a bond of $1,000. Thank you. Alex Carden Santiago. Mr. Carden Santiago. In your case, the court could not locate the PC paperwork in the file, and it wasn't attached to this paperwork either.
I was able to obtain it by our homicide chief.
Yes, ma'am.
1 second. I'll reprint you another copy.
Yeah. No. that's the hand of the homicide.
I also provided a copy to defense as well because she was not able to locate it either.
All right.
May I approach?
Yes, you may. Thank you. So, I am at a, sort of a state of confusion because the officer put on the paperwork attempted second-degree murder, but the affidavit says aggravated second-degree murder, but there's no, I don't see any evidence of death.
Yes, Your Honor. I did speak to the homicide chief about that as well.
Mhm.
And we're both of the opinion, well, there is no aggravated second-degree murder. That's not a statute within the state of Florida. It should be an attempted second-degree murder, as
Okay, well, it was their death, though.
I don't believe there was a death, Your Honor.
Okay.
I believe the last thing within the affidavit was the victim was at the, I can reread it, but my understanding was, last thing within the affidavit was the victim was at the hospital. I believe it's one of the.
Yes, that's correct. It's just that, they did write, aggravated second-degree murder.
Yes, Your Honor. So state, which, a second-degree murder would be a PBL. However, an attempted second-degree murder is also a PBL.
Mhm.
So state would just ask that you find PC for
Attempted.
attempted second-degree murder,
Yes, ma'am.
which is 782.04 sub 2
Okay, hold on a minute. 782.04 sub 2,
and 777.04, which is the attempt statute,
okay.
which would still be a PBL.
All right, at this time, the court does find probable cause for attempted second-degree murder. The statute, that's the statute that he included. He actually included the correct statute on the warrant. And the court will order no bond, no contact with the victim, no return, possess no weapons and no firearms, surrender the knife, and surrender any other knives or weapons to law enforcement within 24 hours of release. Harrison Castillo. Mr. Castillo? Mr. Castillo? Are you Mr. Castillo?
Yes, ma'am.
All right, in your case, the court finds probable cause for possession of cannabis. Says here greater than 20 grams, but the court would set a bond of $500. The court is ordering that you possess no illegal narcotics as a condition of bond. Thank you, sir.
Thank you.
Amade Connor.
Yes, ma'am.
In your case, the court finds probable cause for sale and delivery of cocaine, and bond stays at $15,000. Do you want me to order any special conditions, Ms. Fleming?
No, Your Honor.
Thank you, ma'am. Corvari Flemings? Sir, in your case, the court finds probable cause for count 1, possession of 3,4-methyl-MDMA, ecstasy, greater than 10 greater than 10 grams. Bond stays at $50,000. Count 2, possession of cocaine with intent to sell or deliver. Bond stays at $15,000. Count 3, possession of drug paraphernalia with intent to sell. Bond is set to $150. And count 4, possession of paraphernalia. Bond is set to $150. Thank you, sir. Nadia Dawson. Ms. Dawson, in your case, the court finds probable cause for trafficking in fentanyl 4 grams or more, and bond stays at $100,000. Possession of fentanyl, bond stays at $150. Possession of cocaine, bond stays at $150. Possession of oxycodone or Percocet, bond stays at $150. Possession of cannabis less than 20 grams, bond stays at $100. And possession of paraphernalia, bond stays at $100. Thank you, ma'am. Yes, ma'am.
Your Honor, I would ask in this particular case that you consider reducing count 1 to $50,000. She has no history.
15?
50, Your Honor.
50.
Yes, Your Honor.
Okay.
She has no history. She was very cooperative with the police, and she did state she actually uses it. Nothing in her history indicates trafficking, and all her arrests are possessions. So I just ask that you take that into consideration and reduce the 50,000.
Let's see here, I underlined the weight. It is, well, I underlined a lot, so I can't confirm it. Ms. Fleming, what says the state?
Your Honor, state has no objection. She does have little criminal history, and she was compliant with law enforcement, so state will leave it within your discretion.
The court will, yes, the court will, grant that and, reduce it to 50,000. And I did find the weight. It was 2 point.
I believe it was 2.33 and 2.51.
2.51 or something like that. Delente Epps, Mr. Epps. In your case, the court finds probable cause for fleeing or eluding a police officer and sets a bond of $10,000. Thank you, sir. Patrick Garrett.
In your honor, he qualifies for pretrial.
Thank you. Mr. Garrett, in your case, the court finds probable cause for possession of cocaine with intent to sell or deliver. You do qualify for the pretrial release program, so I am ordering you to be released on that program. I am further ordering that you comply with all of the terms of pretrial release.
Your Honor, just for the record, the state would object to pretrial release.
Yes, ma'am.
He does have a fairly lengthy criminal history, at least 4 prior failures to appear, multiple contempts of court. State doesn't believe he'd be a good candidate, as it is a court-ordered program. And he's shown that he's had an inability to comply with court orders in the past.
Okay.
So just for the record, state would object.
And Your Honor, defense would just note that the last conviction I see was back in 2012.
I'll go ahead on and maintain the order for pretrial release, and I'm going to add an additional requirement to the pretrial release, and that is possess no illegal substances, drugs, or narcotics without a doctor's prescription, and submit yourself to weekly drug testing. The first test must be conducted within 14 days of your release, and every test after that must be conducted once a week. If you fail to comply with that order, then, sir, that will be a violation of my order to allow you to participate on pretrial release. And I'll revoke it. Well, I may not revoke it, but a judge will revoke it. Thank you. Danu Hamelak. Mr. Hamelak, sir, you're charged with aggravated assault with a deadly weapon, and I do find probable cause for that charge. Bond will remain set at $1,500. You're ordered to have no contact with the victim, possess no weapons and no firearms, surrender all weapons and firearms to law enforcement within 24 hours of release, and not return to the location where this incident occurred. Hewitt, Guillermo Hewitt. Mr. Hewitt, in your case, the court finds probable cause for battery on a person 65 years of age or older, and bond is set at $2,500. You're ordered to have no contact with the victim, no return, maintain a separate residence, surrender all weapons and firearms to law enforcement within 24 hours of release, and possess no firearms or weapons as a condition of release. Gerald Kaufman. Thank you, sir. Gerald Kaufman, in your case, the court finds probable cause for burglary of a dwelling. Bond stays at $5,000, and criminal mischief bond stays at $500. You have a second case in which the court finds probable cause for possession of methamphetamine. Bond stays at $1,000, and possession of paraphernalia bond is set to $100. For these cases, the court is ordering you to not return to the location where the incident occurred and have no contact with the victim. Richard Lemon, thank you, sir. Thank you. In your case, the court finds probable cause for escape and sets a bond of, state you have any objection to the court setting a bond of $8,000 in this case?
No, Your Honor.
Further, the court is ordering a finding of probable cause as to count 2, resisting an officer, and setting a bond of $150. Thank you, sir. Renard Mahone, Mr.
Mahone refused, Your Honor.
Okay, Mr. Mahone refused. In his case, the court finds probable cause. Does the public defender wish to waive his appearance?
I will waive, Your Honor.
All right, bond is set at $5,000 and count 1 and $5,000 on count 2. Adrian Mallet, in your case, the court finds probable cause for trafficking in oxycodone less than 4 grams, no, greater than 4 grams and less than 14 grams. Bond stays at $100,000. Providing false ID to a law enforcement officer, bond stays at 100. Possession of cannabis less than 20 grams, bond stays at 100. And possession of paraphernalia, bond stays at 100. You have a second case for sale or delivery of cocaine for which the court finds probable cause and bond stays at $7,500. And thank you, sir. Nathaniel McBride, in your case, the court finds probable cause for possession of 3,4-MDMA ecstasy, and bond will stay at $1,000. Thank you. Joycian Sorrel Muchakarasi, in your case, the court finds probable cause for possession of methamphetamine. Bond stays at $1,000 and possession of paraphernalia. Bond is set to $100. Thank you, sir. Bertley Pilgrim. Sir, in your case, the court finds probable cause for trafficking in methamphetamines greater than 28 grams, and bond stays at $100,000. And count 2, possession of 3,4-methylamphetamine, MDMA ecstasy. Bond stays at $150. And thank you, sir. The first count, $100,000. Second count, $150. Thank you. Charles Ragland. Good afternoon, sir. Sir, in your case, bond is, the court finds probable cause on possession of cocaine, and bond stays at $1,000. As to your out on bond case, count 1, possession of cocaine, the court is ordering a revocation of the bond and ordering a new bond of $5,000. As to count 2, no action. Christopher Snodgrass. Sir, in your case, the court finds probable cause for count 1, possession of cocaine. Bond stays at $1,000. And count 2, resisting an officer without violence. Bond is set to $100. Thank you, sir. Dalton Coolidge Stiles. Mr. Stiles, sir, in your case, the court finds probable cause for possession of cocaine. Bond stays at $1,000. In your case for, which you're out on bond for possession of cocaine, the court orders a new bond of $2,000. And revokes the previous bond, if I didn't make that clear. Thank you, sir. Jose Torres Fernandez. Sir, good afternoon. In your case, the court finds probable cause for being a sex offender and violating by failure to register as required, and sets bond stays at $1,000. As to your out on bond case for failure to register, bond is increased, the bond is revoked and increased to $4,000. You are ordered to register and report as required by law as a condition of bond.
What happened is, it's just,
I did appoint the public defender, that's the young lady. And usually if she wants you to let her know if you want to say anything.
Yeah, okay. You're, thank you.
All right. Thank you, sir. You too. Charles White, Mr. White, in your case, I do find probable cause for aggravated battery with a motor vehicle, and bond stays at $5,000. I find probable cause for grand theft third degree of a motor vehicle. Bond stays at $150, and I revoke the bond in your other case for grand theft third degree motor vehicle and set a bond of no bond. Rayford Williams.
Ron, he's in a wheelchair, we're getting him.
Okay, yes, that's fine. All right, Mr. Rayford Williams, in your case, the court finds probable cause for petty theft with 2 prior convictions, and I will set a bond of $1,000. As to your other petty theft, I revoke your ROR and order a bond of $500. I am appointing the public defender to represent you, sir. Thank you.
Let's see. On the ROR, I'm seeing 2 charges.
Yes, Your Honor, there's a petty theft and a resisting merchandise recovery.
Oh, so there's 2 counts. I order a bond of $500. Well, I'll order a bond of $250 on count 1 and $250 on count 2, for a total of $500. Are there any other people that I need to see?
Your Honor, I'm waiting. The recall, Judge.
Good afternoon. Recall.
We're here later, maybe you guys are early, but we missed our client. Guillermo Hewitt.
Okay, as long as he's from the afternoon session and not from the morning session, I think we're good. Okay. Okay, that's fine. We'll.
What was his name?
Yes, we can do that. I'll need the paperwork back. Madam Clerk.
22 CF 11592.
All right, recalling Guillermo Alberto Hewitt. And this gentleman is still here. And counsel, at a microphone, just go ahead on and announce your presence for the record.
Thank you, Judge. For the record, I'm attorney Matt Boomershine here with Mr. Hewitt, who's to my right.
All right, the court is noting that the defendant is now represented by Mr. Boomershine.
Judge. Yes, ma'am.
And therefore, the court is ordering the public defender is not appointed.
Thank you, Judge. And we have been retained to represent Mr. Hewitt with regard to this case in its entirety, so we'll file a notice of appearance this afternoon.
All right, thank you.
Judge, I've asked the clerks to print for me a copy of the affidavit submitted in furtherance of the warrant that was issued in this case. I understand the court's already called the case and has granted Mr. Hewitt bail in the amount of $2,500 with some special conditions involving no contact with the alleged victim and do not return to certain addresses. I just wanted to make sure I understood who that person was and what the addresses were, and that's why I was asking to review the affidavit. Could I have a moment to just read this before I address the court further?
Yes.
Thank you, ma'am.
Now, I just wanted known for both the benefit of the state and Mr. Boomershine that I read the affidavit on my computer. So I don't have my computer in front of me now, so if you're all are going to be making specific references to the affidavit, please make sure that you give me all the information that you need me to know, since I read it earlier at my computer. It was not attached to the paperwork, so I had to pull it up and read it separately. And I did not print it. Okay.
Thank you, Judge. I had an opportunity to review the affidavit.
Yes, sir.
Would the court mind reciting for me the terms of bail that have already been addressed here before I was present?
I don't recall, Madam Clerk. What did I say? Who has the affidavit? The order, yes, the order. Yes.
I believe what you ordered, Your Honor, was a no contact with the victim,
Mhm.
no return, a separate residences, and a no weapons, firearm, or ammunition.
We're pulling the paperwork right now. It's Hewitt. Yes, ma'am. First name Guillermo starts with a G. Last name Hewitt. I can try to go from memory. I know I ordered probable cause. We found it. Right. Okay. And then I did set a bond of $2,500. Further, I ordered no return to the scene of the location of the offense, to possess no weapons or firearms or ammunition, to maintain a separate residence, and to surrender any firearms or weapons within 24 hours of release. That, and of course, I had appointed the public defender, but I'm now withdrawing my order appointing the public defender. And that appears to be the complete order. We also need to withdraw this $50 dirt fee as well.
Thank you, Judge. From the face of the arrest affidavit, it doesn't appear that there's any alleged personal relationship between the alleged victim and my client, and so I don't think there's any issue with the separate residences. I don't think these individuals share a residence in the past or intended in the future, so that's not an issue at all.
Okay.
The court has advised do not return to the location of the alleged offense, which, as I understand it, appears to be Mall at Millennia at 4200 Conroy Road. Is that correct?
Yes, it was the mall.
So other than that exclusionary zone, there's no other prohibitions other than the residence and the Mall at Millennia, correct?
Well, no contact
Right.
with the victim.
Right.
So where, if the victim is at the victim's home, of course, the defendant shouldn't be there. And if the victim is somewhere else, then the defendant shouldn't be there.
Understood. Okay. No contact. And then the court did find probable cause, and bond is set at $2,500.
I did.
Would the court consider reducing his, I understand there's some financial hardship within the family. Would the court consider reducing his bail to $1,000, which would be the bottom, I think, of the recommended guidelines pursuant to the bail schedule?
What says the state?
Your Honor, state would object given the allegations within the warrant. Also, given the prior arrest history of Mr. Hewitt, all seem to be violent offenses. They believe that the $2,500 that the court currently set is reasonable given the
All
his
right.
history and the warrant.
All right, at this time, the court will decline to reduce the bond. It will remain at $2,500.
Understood, Judge. Then I have nothing further to address with the court.
All right, thank you, counsel.
Thank you, Judge, and thank you for recalling the case.
My pleasure.
Have a great day.
You do the same. Thank you. Are there any other matters, Madam Clerk?
Your
Jill,
Honor,
staff,
I did have an issue.
Ms. George? Yes, ma'am?
I wanted to recall Alex Cardona Santiago, the attempted second-degree murder.
Yes, ma'am.
It is actually not a life offense.
Hold on a minute, let me get the file.
Okay.
Or the order if we already have it, one or the other, or both. I remember the PC affidavit because I just read it. So order is fine.
The only thing I'm asking is that you set a bond, given that an attempted second-degree murder is not a life offense, Your Honor.
Okay, Ms. Fleming?
Your Honor, state was mistaken, given the aggravated, how it originally came in. Defense is correct. He is entitled to a bond.
Okay.
However, state would just have you take into account, he does have a fairly lengthy criminal history.
Okay.
I believe he was released from DOC semi-recently for a firearm or gun charge, and has other violent offenses in his history, and that the victim is currently in critical condition.
I am not going to allow a bond because of many reasons. And probably the most important one is the danger that this individual poses to the public. Based upon the nature of this charge, it was unprovoked. The violence was horrendous. The victim, I have no status on the victims, the wounds, whether they are life-threatening.
Your Honor, would you consider setting it at $1 million, which is tantamount to no bond?
Yes,
However,
ma'am.
He is entitled to a bond.
I will set it at $1 million. I will set a bond because of the danger to the public. That's tantamount to no bond. I understand that, but I'm just very concerned about the public. Yes, ma'am, would you? All other conditions remain as previously ordered. Yes, ma'am, $1 million. Thank you, ma'am.
I read it. And Your Honor, just for the record, defense would object, based on the arrest affidavit, or the warrant that was signed, it stated that they both the victim and my client was in a heated discussion at the time, when the incident occurred. So I just ask that you take that into consideration, but also the fact that although he has, you know, the history, the last conviction was in 2017, and he has no failures to appear, lived in the area for over a year, which is an indication that he will in fact show up for court. But after 2017, for a petty theft, he has had nothing since then. So I would ask for a lower bond, Your Honor. However, defense does understand.
If I had more information about the status of the victim and the type of weapon, the information I have is that it was a approximately 5-inch serrated blade, and it was jammed into the victim's chest.
Yes, Your Honor.
And he began to bleed profusely, and the victim was not armed. And I still believe that my interpretation of the facts is that it was unprovoked. Just because you're having a heated or verbal disagreement does not mean that someone needs to draw a weapon. And so the court believes that the state has convinced the court to set a bond of $1 million, and that is appropriate, and that's where we're going to leave it at right now.
Thank you. I understand what you're saying, and I'm telling you, you're gonna have to wait. I'm gonna work on it.
All right, are there any other matters?
Nothing from the state.
Nothing from defense.
All right, thank you all. Court stands in recess.